Well, good morning, everyone, and welcome to Navigating the Workplace in the Era of Coronavirus, Guidance for Safety and Legal Compliance. Thanks for attending and hope you are all well. My name is Brian Schill, and I'm the Executive Director for the Peters Township Chamber of Commerce, and facilitating with me is Kelly Keene, Operations Coordinator. A little bit about the Chamber. We're a 501c6 membership-based nonprofit. We're not part of any government agency. Many folks think we're part of the township, but we are our own nonprofit. Our funding primarily is composed of each member's annual investment and events and sponsorships. The mission of the Chamber is to provide connections, opportunities, partners, and resources to grow our businesses and serve our communities. Quite simply, we promote, advocate, connect, and educate. In addition to Peters Township, our area of coverage also includes the South Hills and Northern Washington County. So joining us today from the law firm of Peacock Keller is Rachel Lazowski. Hello, Rachel.
Hi, Brian. Good morning.
Good morning. So Rachel concentrates her practice upon education and employment law. She represents private companies and nonprofit entities in employment law matters, including employee discipline, hiring and termination, and counsels these clients regarding compliance with myriad employment laws, including the Family and Medical Leave Act, COBRA, and federal and state anti-discrimination laws. All right. Thanks again for joining us, Rachel. You doing all right?
I'm doing all right. I'm doing okay.
Sounds good. So at this point, I'm going to let you take it away. Thank you.
Okay, great. Good morning, and thank you, Brian. I don't need to do much more by way of introduction. I think Brian introduced me well. The only edit I would make to the description of my practice is within the last 2 months, my practice has become almost exclusively employment law, subheading COVID law. It is just unbelievable how quickly, it's becoming such a trite phrase, how everything changed overnight, but it did. And the employment law side of my practice has just become almost exclusively focused on these COVID issues in the last 2 months. So it's really quite a timely opportunity to present on this today. I wish we did not need to be talking about these issues. I wish we were back to business as usual. I wish I were in front of all of you in person. That's the way I'd rather present and the way I would rather deal with things. But here we are. Employment law in the time of coronavirus. And again, it's so timely because, as we're all aware, we are moving in our region to yellow tomorrow. And I'm sure that many people greet that with mixed feelings, great eagerness to get back to business. Certainly continuation of the uncertainty that we've all been living with for these 2 months now. I will say at the outset that this webinar cannot possibly cover every issue and every question in this area, partly because of our time limitations, partly because there are some questions for which there are just no answers at this point. So we are doing our best. Our firm is constantly in contact among our litigators, our employment attorneys, our business attorneys, trying to deal with, okay, what do we know for certain? What is the guidance that is definite? What is up in the air? And how can we best counsel our clients to act reasonably in light of all of this? So we're going to talk about quite a few things today. I've compiled information based on questions I'm receiving, kind of the FAQs from my clients. So rather than start as a Q&A, I'm just going to go through what I've been dealing with as the most frequently asked questions, because I think it will address a lot of things preemptively that you may be pondering. And then we'll have time for Q&A at the end. We're going to talk about leave laws. We're going to talk about unemployment compensation. We're going to talk about safety in the workplace when you transition back. And I'm going to start all of this under the umbrella of talking about liability. Because really all of this fits under the umbrella of liability. And as eager as everyone is to start doing business again, no one can do business effectively or efficiently if they are constantly either anticipating lawsuits or defending them when they come. So we're going to talk about one of the big questions everyone has. What is my duty? How far do I have to go in trying to protect my employees, trying to protect the public, trying to address health issues internally and externally? What is my obligation? Certainly, I want to do the right thing. I want to keep everyone safe and healthy, but how much is too much? How can I balance all of this with running my business? I've been talking a lot with my litigation partners about what do we think the standard will be if employers, businesses, nonprofits are sued for failure to protect, either by members of the public or their own staff, their own employees. The reality is this is untested. There's no case law on this yet because we have not experienced coronavirus lawsuits yet. I will tell you there's a push, some movement afoot by some members of the plaintiffs' bar to set a strict liability standard, meaning simply if you walk into work and you become injured at work, or you become rather ill because of exposure at work, or you do so as a member of the public, that employer is strictly liable simply by virtue of that illness being incurred. We don't think that will fly. We don't think courts can possibly adapt that. On the other side of the spectrum, there is discussion, and there has been some movement by this state's administration to grant broad immunity to healthcare providers, hospitals, doctors. Basically, if they're acting reasonably and in good faith, they will not be liable. We don't think for the average employer, immunity will go that far, and that freedom from liability, that's too far at the end of the spectrum. So without other guidance, basically what I'm advising my clients is act reasonably. The law of the reasonable person, back in the day, we called it the law of the reasonable man. No, we don't do that anymore. The reasonable person tends to apply. So how do we act reasonably? Let's get to the nuts and bolts. Well, one of the first questions you ask in acting reasonably is there a law? Is there guidance? Is there precedent? Is there some rule to comply with? Because certainly it's reasonable to do that, and it's unreasonable not to. Now, I'm going to preface this by saying, as an attorney, it is not appropriate for me to comment on whether I think any of the governor's rules, the CDC's rules, anything like that, whether those rules themselves are appropriate or inappropriate, reasonable or unreasonable. That's not my role. I'm not going to do that. I'm not getting into any political discussion. This is a safe space from all of that today. But what I'm saying to you is, because we do have directives from the governor, the reasonable person will follow those directives. So I'm just going to review those quickly. I'm sure as you're going back into yellow, you've reviewed these, but there are nuances within them that I think that are important for you to know. So first, internally, when you're opening up your own business, it's the common sense things. You're going to keep social distancing. Everyone has to wear masks, and we're going to get into that in some detail. Meetings and trainings. They have to be virtual if possible. If not, no more than 10 people in the room at a time, 6 feet apart, of course. People who have been working remotely, if it's feasible, if it's been working, then that needs to continue. One of the biggest areas of concern is what if there is exposure? And I'm not talking just the possible general fear, anyone could be carrying it at any time. We know that, unfortunately, but if there has been exposure to a probable or diagnosed case, within your workplace, either from a member of the public or from an employee, you have to do all of the disinfecting that is required, all per the CDC requirements. You need to wait 24 hours if possible before doing that. If that's not feasible, you dig in and you do that right away. One of the more difficult and controversial issues is the governor is directing essentially contact tracing, that anyone who has been in close contact with a probable or diagnosed case needs to be advised of that and needs to be made aware. So the question that folks often have is, well, how is someone made aware of that without giving away the privacy of the person to whom they would have been exposed? And the answer is a lot of those HIPAA requirements, personal health information privacy, are going by the wayside in favor of contact tracing. So you give as much information as necessary so that people who have been in close contact can be informed. You don't give more than necessary. So I'll use an example. Let's say, heaven forbid, it's me, okay? Let's say I, hypothetically, am the probable case. I have not worked out of our South Point office in months, okay? But I may be working out of our Washington office. So everyone in the Washington office can and should be told, me by name, what is the probable or diagnosed case. Anyone who was within 6 feet of me for 10 minutes or more within 48 hours of the onset of my symptoms would be considered to have been in close contact. Now, do we tell all of those people, hey, only if you were in contact with Rachel within these strict parameters, it's close contact, and otherwise don't worry about it? You know, I'm not advising people to measure it down to 9 minutes versus 10 minutes versus 5 feet versus 6 feet. I think, again, a reasonable approach is to say, you know, if you were working with Rachel, if you were in her office working closely, be advised she is a confirmed or diagnosed case, and then you act accordingly. Okay, well, then that's the next step. How do you act accordingly? Well, if anyone is sick, if anyone has any symptoms of COVID, either because of workplace exposure or for any reason, you are required to tell them that they need to report that to their supervisor and that they need to go home, and you need to make it available and feasible for them to do that. Now, what if someone has been in close contact, exposed, but as far as you can tell and as far as they can tell, they are asymptomatic? In that situation, the governor's guidance actually does not require that they be sent home. The general CDC guidance does require 14 days of isolation. The governor's guidance refers to specific CDC guidance that truly only applies to critical infrastructure workers. And it says that as long as someone is asymptomatic, they can continue to come to work. They need to be self-monitoring their temperature, their symptoms. If you have an internal occupational medicine practitioner, an OCMED, one of the terms I'm learning in all of this, they need to work with the OCMED. They need to be measuring their temperature. Everyone coming into the workplace after any exposure to a probable or diagnosed case needs to have their temperature taken every day upon entry. And if their temperature is 104 or higher, they need to be sent home. So that's the guidance for exposure. And of course, we're limiting non-essential visitors and things of that nature. Now, if you are a business that opens your doors to the public, there are additional guidelines. And when I say guidelines, what I really mean is requirements. Governor's office uses the word guidelines. They are requirements. They need to be followed as such. And the guidelines for the public, you're probably aware of that as well. Appointment only, if that's possible. If not, you can only have members of the public in up to 50% of capacity at your business at the time. You need to modify your hours to ensure time for restocking and cleaning. If you are a business that delivers medical supplies or provides medical supplies, groceries, or medicine, you need to have an alternative available other than requiring people to come into the store. Masks. Every member of the public needs to wear masks with some exceptions. And I know you're dying to hear about masks. I'm going to get back to masks in a moment. But generally, if you cannot comply with these requirements as a business open to members of the public, you are back to curbside delivery, and you need to do that with social distancing and all other mitigation measures that would be feasible. So then we come back to masks. So let's talk about masks within the workplace for your own employees first. Every employee is now required to wear a mask. There are 3 exceptions. If the employee is alone in his or her office with the door closed, no contact, they can take that mask off. If it would be a safety issue in any tasks they are performing, the mask is not needed. If they have a medical condition, the mask may not need to be worn, but this is a very, very difficult area. It overlaps with ADA, Americans with Disabilities Act concerns. Even if you are a significantly small employer such that ADA does not apply, unless you have just 1 or 2 employees, you're going to be under the Pennsylvania disability laws, and those will apply too. And you're going to need to go through that discussion of reasonable accommodations. If an employee says to you, I'm not wearing a mask, I'm just not doing it because I have a medical condition, it's a gray area as to whether or not you can ask that employee for medical documentation. We've hashed this out at length in our firm, And we have decided to advise clients to err on the side of asking for that documentation. You could do that in another disability situation. We're advising you can do that here. If they provide the documentation, then you need to go into the accommodation discussion. Okay, is there something else you can do to comply with the spirit of what is being asked for safety purposes? So can you wear a light scarf? You know, can you wear a light bandana? Is there something that works in some other way for you? Can you cover at least your mouth, you know, if not your nose? If there is no way that you can accommodate it and they refuse to wear the mask, particularly if you don't have medical documentation, but even if you do, if there's no way you can accommodate it, remember that under general disability law, if you can't make an accommodation and someone can't then comply with work rules, they can be dismissed. So you may find yourself in that situation, but these are case by case. Again, I urge you to understand that it's a very gray area. So we would urge you to reach out to legal counsel and work with the employee's doctors as well. You know, this is going to be an area in general where you're going to want to rely on legal expertise, at times in tandem with medical expertise, through many of these issues. And that, number one, that can show you to act reasonably. And number two, you know, frankly, it takes some of the burden off of you as an employer if you are acting at the advice, you know, of counsel and or doctors. You're in a better position than if you're kind of trying to wade through it on your own as you go. Remember internally as well that you need to post a sign. You can find this through the governor's website. There is a poster, the COVID-19 safety procedures for businesses, that needs to be posted. It needs to be signed by a corporate officer. It also needs to be signed by a pandemic safety officer. So if you've not designated someone to that position yet, you need to do that. And that person needs to sign off as well. Okay, we've covered masks, we've covered the general reopening laws. I'd like to transition now to issues more specific to employees and reporting to work and not reporting to work, and concerns that they have about doing so in light of what we're facing. And I'm going to break those concerns into two groups. Employees who just have general concerns to the same level as all of the rest of us. They don't have any specific vulnerabilities, health conditions. They're not caring for anyone who either is a child, you know, trapped at home, or someone else with a health condition. They don't have any special circumstances. They're just saying, as a member of the general public, I'm afraid to go to work because we're all at risk, right? And I've been hearing that from some employees, and you may be as well, because there is a level, and I'm not sure any of us are sure of the level of threat, but there is a level of threat to everyone. So we're hearing general questions. I just have general fears. Do I have to come to work? What options are available to me if I choose not to? For that group with the general fears, again, the theme here is going to be the reasonable person. The first and easiest reasonable step is, do you have leave policies that are already in place? Do you have a PTO policy that doesn't require an employee to give you a good reason? They can use it for vacation, they can use it for personal leave. You certainly don't want to be any more restrictive on people who have coronavirus fears than you would be in how you would apply your policy generally and across the board. So if someone can take a personal day or even a sick day without documentation, or anything that they may wish to do, yes, you know, they can go ahead and do that. Brian, do you want me to answer that question now, or that you just typed in for me, or come back to on the pandemic safety officer? Brian just asked a question if the pandemic safety officer is needed for businesses of every size. I'm not aware of any exception for a small business. I'll look into it and confirm. If there is an exception, I will let you know, but I'm not aware of any. And I'll just make a quick note of that. My understanding is it's businesses of all sizes. Okay. So again, when your employees are asking to take leave or for some accommodation just of general coronavirus fears, if you have policies in place that they could use for that, let them use it. Do you need to offer additional leave just for generalized fears? You could. There's nothing to say you don't have to or that you have to. I would suggest that doing so might be both overkill and underkill, in the sense that this is going to be with us for a long time. Offering 10 additional days just to address general fears doesn't really solve the problem, and so therefore it might be even more than is necessary, again, for those general fears. Now, here's a very common question I'm receiving. What about the employee who says, forget it, it's too risky, I would just rather quit, collect unemployment, than be at risk of this? Well, you start with what you know, right? So the general unemployment law parameters are: you do not receive unemployment benefits in Pennsylvania if you are terminated for willful misconduct, or if you voluntarily quit, with the exception that if you voluntarily quit for what is called a necessitous and compelling reason, you are generally eligible for comp. So the question is, to what extent is a coronavirus fear a necessitous and compelling reason for quitting? I'm not aware of any test cases of anyone saying just generally I'm afraid and getting their unemployment comp, but this is all working through the system, and remember how many cases are backlogged. The only guidance I have found on the UC website says, in situations where someone has a particular vulnerability due to their health conditions, or because in a situation where if someone's hours are cut, but they quit because continuing to work is essentially not giving them any benefit at all, in those situations, maybe they'll receive unemployment comp. The UC office will look at it on a case-by-case basis. So basically, it's what I said at the outset. We just don't know. Employees are taking their chance if they do that. Some employers are attempting to kind of be generous and bend the rules and respond to questions from the UC office by saying they ran out of work, it was a lack of work, and then the employee can generally get their unemployment comp. But if it's a general coronavirus fear, we just don't know. Even if it's frankly a individualized fear, we don't know yet. There was a press conference held by the director of the Department of Labor and Industry just this past Monday, and the director said that if you are in a red zone and you refuse to go to work, you may still get your benefits. That's not binding. That's a statement at a press conference. You take it for what it's worth, but the director did say that. The general nuts and bolts of how UC is working now. Employees should still file for regular unemployment compensation. And when I say regular, let me just preface that with a few additional points. You have the 39 weeks of standard unemployment compensation now. It's been extended. It was fewer than 39 weeks before. You now can get up to 39 weeks of unemployment compensation at the regular rate, the regular PA rate that applies. Then under federal law, there is the additional $600 a week if you have certain other conditions that we'll get into. So the regular UC, the regular rules apply if you are laid off, if you are terminated, if your hours are reduced, and now if you can't work because a medical official or a public official quarantined you or subjected you to self-isolation due to COVID, you can apply for that general unemployment comp. Once that runs out, you can also apply for the additional $600 if you have a COVID-related reason. In addition, people who would not have in the past been eligible for even regular unemployment compensation, they now can be eligible for that $600. So who are those folks? The self-employed, independent contractors. Well, how can they have unemployment? They're self-employed. There's a test, and it will be case by case. If you have lost enough business that your circumstances are substantially reduced, you may qualify for that. And you have to have a COVID-related reason. So certainly if you're diagnosed, if you have a presumptive case, if you're caring for someone in any of those situations, if you are the primary caregiver for a child kept at home, if you were offered a job and you've not started that job yet, but you can't start because COVID has affected that workplace's operations. If a job offer was rescinded, if you've become the #1 breadwinner in your home, if you've had to quit because the diagnosis keeps you from performing your duties. those are reasons, again, if you're not eligible or if you have come to the end of your first 39 weeks, you can receive that additional $600. I'd like to transition now into that second group of employees who might be looking to take leave or have other accommodations made due to COVID reasons. So people who are more medically fragile or people who have caregiving responsibilities. If they exhaust paid leave or any other accommodations that you're willing to make for them, teleworking, that kind of thing, what might be available to them? And I'm not sure if you're aware, but there's been a lot of discussion in general about the CARES Act. There's also the Families First Coronavirus Response Act that was enacted first in March, and then there have been some updates throughout April. There are a number of different laws under that overall act. The ones you need to be aware of as an employer are the Emergency let's try this again. The Emergency Family Medical Leave Extension Act. That's where Brian's great video editing will come in. And the Emergency Paid Sick Leave Act. So first, we'll call it the EFLA, the Emergency FMLA. This applies to nearly all employees, probably all employers rather, probably everyone we're talking with here today. So if you have more than 500 employees, it doesn't apply. If you have fewer than 500, for the first time ever, there's a circumstance in which employees can have paid FMLA leave. If they need to care, if they cannot work because they are the primary caregiver for a child, and that can be their biological child as well as step, foster, ward of the court, adopted child, or someone who is over the age of 18 but is mentally or physically unable to care for themselves. If the employee cannot work because that child or incapacitated adult's school or place of care has closed due to COVID, that employee is entitled to 12 weeks of FMLA leave. 10 weeks of that will be paid. The first 2 will not, but there's a caveat to that we'll get to. That leave is not in addition to any other FMLA leave they may take during the year. So if that person has already taken FMLA for any other reason, they had a child, they were ill, or if they take other FMLA leave later in the year, the limitation overall will still be 12 weeks. Now, there is an exception for small businesses of fewer than 25 employees, but you need to demonstrate that allowing this leave would be a substantial hardship on your business. There's a 3-part test for that. It involves basically if it would keep the business from operating even in a minimum capacity. But if allowing the leave, takes people out of your workforce, even if they have necessary skills, they're pretty critical people, but you could still operate minimally, then you still have to offer it, even if it takes you down to that minimal level. They can take this intermittently. It can be a day here, it can be a day there. They do need to have been employed for 30 days prior to taking that leave to qualify for it, but there are some caveats to that as well. Then we cover the Emergency Paid Sick Leave Act. This, again, it's for anyone who employs fewer than 500 employees, probably going to be most employers that we're talking with today. There is some overlap with the Emergency Family Medical Leave Act in the sense that the Emergency Paid Sick Leave also applies to those caregiving situations that I just mentioned. The first 2 weeks that FMLA leave would be unpaid. You have to run that concurrently with the Emergency Paid Sick Leave, so they would be paid. This is an important piece I don't want to forget. Pay under the FMLA, the emergency FMLA, is at 2/3 of an employee's regular rate of pay. If it's a part-time employee, the number is averaged based on the hours they've worked over a 2-week period. Emergency paid sick leave is at their regular rate. So if they're taking those first 2 weeks of FMLA concurrently with emergency paid sick leave, that's regular pay, then it drops to 2/3. EPSLA, emergency paid sick leave, applies to certainly anyone who is under a quarantine or self-isolation order or caring for someone who is. It applies to anyone who has been advised by a healthcare provider to self-quarantine due to COVID concerns, or if you're caring for someone who is, those concerns can be a diagnosis, or can be the situation of a medically fragile individual as well. You don't have to, the employee does not have to provide an excuse, but they do have to provide the name of the healthcare provider. And then one other situation is if an employee is experiencing symptoms and they're seeking a diagnosis. Emergency paid sick leave is 80 hours for full-time employees. And again, it's a number of hours based on the hours worked over 2 weeks for part-time employees. There are formulas to how to calculate that. There are some nuances you would need to work through when you get into the paid portion of FMLA. If your employee wishes to run paid leave that you've already provided as an employer and that they're entitled to concurrently with that FMLA leave, they can do that. Again, we just recommend that you talk with your legal counsel to navigate that, because administering how these two types of leave plus any of your internal leave work together, it's not overwhelming, but it just requires a logical kind of step-by-step approach to make sure you're doing everything correctly. If you do provide the emergency family sick leave, the emergency paid leave, first of all, you're required to do so. And if you do, you get a tax credit. If you don't do it correctly, if you don't get the documentation that you need to show that you actually were required to do it, there's nothing to stop you from being more generous. But if you don't get the proof that it was needed from that employee, then you likely won't receive your tax credit. So then the last area I wanted to touch on before we get into questions is the situation of granting additional sick leave or any type of time off as a way to address employees' fears or particular situations related to COVID. And you can't talk about this without talking about the need to have your employees report certain things to you as part of this entire process and this entire landscape. So we already know that employees need to be required to tell their employers if they're experiencing any COVID symptoms, whether that exposure was in the workplace or not. It's a very simple system. You tell them to report, and then you tell them to go home. Likewise, they need to tell you if they believe they've been exposed. Now, how far do you need to go in explaining to them what it means to tell you what the threshold is for reporting to you any possible exposure? Well, again, we've covered that definition of close contact. You know, the 10 minutes within 6 feet, 48 hours. I'm not telling any of my clients to have a policy that says directly within those parameters, you know, that's the only time they report. I am telling my clients to have their employees report very generally if they think they've been exposed. And some of this flies in the face of the advice we often give, which is try to be as consistent in every case of leave, of requests for accommodations as possible. But here, so much of this just has to be case by case because the facts are just going to be so different. So it's not a black and white directive that any case of exposure needs to be reported to an employer. If that happens outside of the workplace, or if they think it just is a potential exposure, but we think the most reasonable and the most most protective approach from a liability standpoint is to have them do that. Now, once they report that possible exposure, this is where you may need to be working with, you know, your occupational medicine, if you have one, with the employee's doctor, if possible, certainly with legal counsel, because the situations will vary. If someone says to you, you know, I was near someone in the grocery store, they were coughing and I'm just concerned, but you want me to report everything, so I'm reporting it. Well, that could be a different situation than someone who is living in a home with a person, certainly with a probable case, you know, and there are a number of situations where doctors are simply saying this is a probable case because there isn't enough testing, you know, in any particular situation, or they don't want to send someone for a test. So you might have something closer to an exposure than something that's sort of a passing concern. You're going to need to evaluate that case by case, and then treat like cases as similarly as possible. So if people in similar situations are asked to go home for 14 days, you know, then you want to make sure in each similar situation you're doing that. But like I said, this idea of giving notice to the employer has to work in tandem with backing that up on the other side. So it's very difficult to ask people to give notice of every possible symptom, every possible exposure, and then not have a safety net in place for them to know that they can take time off, number one, without punishment, and then possibly without economic difficulty. Now, it becomes a practical issue, though, because if you're asking for every one of these possible scenarios to be reported, well, my goodness, does everyone get unlimited paid leave, to address every cough, every symptom? Again, these are things you're going to have to work through, both in developing the policy and administering it. I would say this: we don't have precise guidance from the CDC on what you may need to do with giving additional leave. CDC simply tells us, be flexible, be generous when you can, and be creative. And the number one issue is don't be punitive. So I think, again, everything comes back to reasonableness. This is not the time to foster a workplace culture of a lot of martyrs, people who are trudging in with the cough and the runny nose because, darn it, I love my job. This is a time when we need to flip that script to the way that you demonstrate company loyalty and care about your employer and your colleagues is keeping them safe, And that's not just good public health, that's good liability avoidance, because you don't want that lawsuit to come and have those employees testifying on the stand that you fostered this culture of, okay, these are the rules, but really, unless you really are dying, a cough is a cough, get in here. That's not going to be helpful in defense of an action if, heaven forbid, someone becomes seriously ill with COVID and it can be traced to your workplace. So to the extent you can back that up and support it, the CDC recommends some creative approaches, like perhaps a sick leave bank. So employees who have a number of days that they are entitled to and might be using anyway can donate to someone, who might need it because of COVID symptoms or possible exposure. They could take an advance on sick leave that they might be entitled to the next year. You can provide unpaid leave. That's not necessarily punitive, but again, you have to weigh if someone needs to be away from work for a long period of time and that's a significant economic impact, does that become essentially punitive? So we've covered leave, we've covered unemployment, we've covered the basics of getting back to work. These are the things we've been grappling with. Answers may be evolving as this evolves. It's a fluid situation, but we believe that this is the most reasonable guidance at this point. You comply with the things that we know we have to do. Beyond there, you act as reasonably as you can, and you certainly reach out and contact legal counsel as well as doctors to the extent that you can. One more thing I wanted to mention, returning to the workplace. If you already have a policy that requires a note that says someone who has been out for a certain period of time is safe to come back, definitely still require that note. The CDC is saying that you shouldn't be requiring clearance to return from every COVID leave because it's just hard to have doctors available to make that many written statements available. But we say you should still at least ask. And again, it's kind of case by case. If someone was out for a short period of time with a cough, maybe you won't be hard on a doctor's excuse. But if someone is out with a case of COVID, we very much would recommend that you get a clearance, a negative test case, a negative result if you can. Okay. So now if we have some questions, I think I saw a few coming in by chat. See if I can bring that up again. Main questions. If a part-time employee is called back and doesn't feel comfortable to work again due to family concerns, any thoughts on the best way to proceed? Do we terminate them since we're following all CDC guidelines? Do we schedule them first? Not to head down a rabbit hole, but what about PPP payments? Okay, so let's start with, first of all, I'm not sure for purposes of this first question if part-time or full-time matters. I think this would be any employee in general. Okay, so due to family concerns, I don't know what the specific family concerns are. remember that if the employee himself or someone that he's caring for has a vulnerability, a particular medical vulnerability to COVID, and a healthcare provider has advised of that, and the employee has a name that they can refer you to, and the employee says they can't work because of that, and again, caregiving would count, that would likely be a situation where they can at least take those 80 hours for full-time, calculated amount based on the average for part-time, of emergency paid sick leave. So they would have that most likely at the outset. That would be a COVID concern. If you grant that and they're not technically entitled to it, the worst that would happen would be you'd lose the pay, obviously, what you're paying that person, and you would lose the tax credit. But they may very well be entitled to that. After they have that period of time, you can offer additional leave if you want to. You don't have to. I think then you're back in the situation where they can resign, you can terminate them, and unemployment may or may not be available. Again, UC office is telling us they're evaluating that case by case. There's a possibility, and this is just kind of a reach, but there's a possibility that you may have an obligation to give that person some regular FMLA leave as well. You really would want to talk to a lawyer before you would wade into these waters, because one of the concerns I'm seeing, particularly in an employment law blog I've been following, is people who say they have these specific concerns. It's usually because they or someone they care for, there's a disability, right, that's underlying it. That triggers ADA. So all this other paid leave issue aside, remember the basic ADA and Pennsylvania discrimination law requirement is that someone has to be reasonably accommodated for any disability. Sometimes leave is a reasonable accommodation. If that disability is COVID vulnerability related, then all of this new law aside, it may be viewed as a disability accommodation that you need to give them FMLA leave before you would terminate. It's going to be fact specific, so you want to talk to someone, but that's a possible pitfall before you would just move to terminate. But certainly after you've exhausted everything, paid leave, possible FMLA, if there's nothing left, you may then be at the point where termination is appropriate. Okay, PPP payments. So that if that's paycheck protection, I think that's a topic for another day. That's more, Don's bailiwick. I've not dealt with the PPP beyond a cursory level for employers. I'm more strictly the employee side. So I think that's a Don answer. If you have called, left message, and text message to notify of returning to work and the employee has not responded, thoughts on next steps? Okay. Well, generally, hopefully you have a policy in place for what you do if an employee is essentially abandoning their work. You've documented this, so that's a good thing. Just because of the emergency situation, if there's any family contact, emergency contact you could reach out to just to be sure, in case this person is seriously ill, you would want to do that. If beyond that, they just haven't responded, you're probably in an abandonment of work situation and you can move to cut those ties. But you also definitely want to look at any policy you have for abandonment, for reporting in, before you would do that. Okay, other questions?
Okay, Greg in Cardona has a couple questions he's going to ask you, if you don't mind.
Sure.
Good morning. Thank you, Rachel.
Good morning, Greg.
My couple questions are based around the workplace and employee stuff.
Sure.
You had mentioned about having to wear a mask for employees unless they had their own workspace and office. My question is about that. If you have an open workspace that doesn't have offices but still 6 feet from each other, would they still be required to wear a mask?
Yes.
Okay.
Yes.
second question, you said the exceptions to that are, one of them was a safety issue. Who determines the safety issue, the employer or the employee?
I would say ultimately the employer would have that. Yeah, I would say ultimately that's the employer.
They could say that
you know,
because of safety issues, they're not required to wear a mask.
yes, I mean, generally the employer makes the safety rules, right?
Okay.
So, and you enforce them. Now, if someone comes to you and says they think it's unsafe, you want to listen to that. You want to hear that concern. You remind me that I forgot to mention the masking exceptions for members of the public. So if anybody wants to hear about that, I'll be glad to get into that. If you have other questions, we can discuss that as
Okay. Yeah. So one more question that I had about the workplace again. Just like you're putting signs up, you see them everywhere before you enter. Here's what we require you to enter.
Yes.
How do you feel about having something written that you present to your employees so that they're acknowledging that they were told to wear a mask, and if they don't have one, it's kind of on them instead of on the employer because I asked you to wear it. And so the employer's not watching every single minute of every single employee. And if they take their mask off, it's not like you're sending them out, so.
100%. And I had a note that I skated by that said document, and I underlined it 10 times. So you're speaking my language 100%. Yes.
Okay.
Every one of these protocols, they should be advised of in writing, should respond, yes, we know this, we've been, and so then you're absolutely right. Anytime they go against it, they're going against what they've been told, it's documented and they signed off. Absolutely.
Okay. All right, thank you.
Would we still be required to FMLA to offer FMLA if we are all small business with all part-time hourly that is not offered FMLA in the past? Yes, unless you meet those exceptions, and the exceptions are self-policing. It's basically, again, the standard is if it would compromise your business to the extent that you can't even operate in a minimal capacity. Nobody is checking that right now, but the regulations say, and this is coming from the federal government, that you need to document why that is, how it affects your business, and have that documentation ready in case anyone checks it. But generally, yes.
Okay. I do want to shout out to Karen on the call with us from Beef Jerky Experience. She's been asking these wonderful questions, but more importantly, she sent me a message back when we were talking about the pandemic safety officer, and we want to congratulate her on her recent promotion. She is now the pandemic safety officer for Beef Jerky Experience. We know that is a coveted award that not everybody can have. But was really interesting, the Linguses have a store not only in Tanger, but they have one, Tanger here, but they have one at the Grove City outlets as well. So that is an interesting perspective because they are currently in the yellow and have been for a week, and they're open. And they actually had the Department of Agriculture stop by and ask them about, these requirements, and do you have a PSO and things like that. And she did send me a message as well, which is pretty cool, that they're open. Everybody's working fine for them, which is good. Attitudes are great, and they got all the plexiglass up and all the appropriate signage and all that good stuff. So it was good to see that someone's actually experienced this. So we want to thank her for her comments as well. So
wonderful. Thank you.
But
thank you for your insight.
I think that's it. Anybody else have any questions? So I think that'll do it. Any closing comments, Rachel?
If you wanted to hear about masks for members of the public, just know that generally they have to wear them unless they have a medical condition. You can't ask for documentation of the medical condition, but you can ask, do you have a medical condition? If they say they do, end of discussion. If they say they don't, you can and should turn them away. Other than that, for closing comments, I think I'm glad to hear that at least, one business is already stepping into this and it's going well. I think there are going to be hopefully many examples of that people are just complying and people are eager to make this happen and do it in a safe way. Equally, there will be questions that arise, and we just encourage you, reach out to us, reach out to, legal counsel, reach out to medical experts, and do what you can to keep your business running, to keep yourself safe and happy and healthy, and hopefully we can transition from new normal to some version of normal sooner rather than later. And thank you all.
Well, thank you very much, Rachel. We really appreciate you taking your time out of your busy schedule to share the information. It was very informative. If nothing else, 61048 for contact tracing. I'll remember that. So try to keep that going. But again,
Okay.
we really appreciate, like I said, you coming aboard and sharing that expertise. Just a couple closing notes. The chamber is open for business, so everyone knows. It's just we're doing it remotely. We are not open to the public. So couple of things. The email is best to contact us, and that is info@ptcoc.org. You can call us on our line, which is 724-941-6345. We check that quite frequently. Also, please be aware we have the new Facebook group that we started, which is the Peters Township Chamber Community Support. Please feel free to join that and to add items to that is especially related to COVID. So if you have a change of hours and that, so starting at midnight tonight, there's going to be a lot of changes. So if you're listening to this at any point, we would highly recommend you access this Facebook page and let us know what you're up to. So in addition, we also have our chamber website, which has a lot of information, and our normal Facebook page. So thanks again to Rachel and to all of you for joining us today. This concludes our webinar. Stay well, my friends.